I was sitting on my front porch drinking coffee when I saw the white sedan pull into my driveway, and something about the way two people in suits stepped out told me this wasn't going to be a pleasant Monday morning. The woman was maybe 50 years old, blonde hair pulled back so tight it looked painful, wearing a pantsuit that probably cost more than my monthly mortgage. The man beside her carried a leather briefcase and had that hungry lawyer look about him. They walked up my driveway like they owned it, which was ironic considering what was about to happen. "Thomas Crawford?" the woman asked, though it was more of a statement than a question. "That would be me," I said, setting my coffee down on the porch railing. "Can I help you?" "I'm Patricia Whitmore, president of the Meadowbrook Heights Homeowners Association. This is Douglas Fenton, our legal counsel." She gestured to the lawyer, who was already pulling papers from his briefcase. "We need to discuss your property violations." I felt my jaw tighten. I had bought this house 6 months ago specifically because it was outside the HOA boundaries. I had checked twice. "I'm not part of your HOA." Patricia's smile was thin and cold. "Actually, Mr. Crawford, according to our records, your property falls within our jurisdiction, and you've committed several violations that need immediate correction." Douglas, the lawyer, stepped forward, handing me a thick stack of papers. "You failed to maintain approved landscaping standards. Your fence exceeds the permitted height, and you've made exterior modifications without board approval. These violations total $15,000 in fines." I stared at the papers, then at them. "You've got to be joking." "I'm not paying you a dime. My property isn't part of your HOA." "The subdivision map clearly shows otherwise," Patricia said, pulling out her phone and swiping through what looked like a digital map. "See, your lot number 47 is right here within our boundaries." "Then your map is wrong," I said flatly. "I have the original deed to this property. This house was built in 1890. Your HOA didn't even exist until the 1970s. Patricia's expression turned smug. "Property boundaries and jurisdictions change, Mr. Crawford. The current plat map is what matters legally. You have 30 days to pay the fines and correct the violations, or we'll be forced to place a lien on your property." "Get off my land," I said, standing up. "I'm 6'3" and spent 20 years working construction before I started my own carpentry business. When I stand up, people notice. And don't come back without a court order." Douglas cleared his throat. "Mr. Crawford, I strongly advise you to reconsider. Fighting this will only cost you more in legal fees." I said, "Get off my property." They left, but Patricia turned back at the car. "You'll be hearing from us, Mr. Crawford. Nobody defies this HOA." I watched them drive away, then looked down at the papers in my hand. The violations were ridiculous. My landscaping was unkempt because I let wildflowers grow in the back corner. My fence was 6 inches too tall. I had painted my shutters dark green without approval. It was insane. I pulled out my phone and called my real estate agent, Marcus Chen, who had helped me buy the place. "Marcus, I need you to pull every document from my closing. Everything about property boundaries and the HOA. What's going on, Thomas?" "The HOA is claiming I'm part of their jurisdiction and hit me with 15 grand in fines." Marcus swore softly. "That's impossible. We verified you were outside their boundaries. That was your main requirement. Can you get me those documents today? I'll have them to you within the hour." While I waited, I went into my basement where I kept important documents in a fireproof safe. When I had bought the house, the previous owner's estate had included a metal box of historical documents about the property. I hadn't looked through everything yet, but I remembered seeing old deeds and papers. I carried the box upstairs and started sorting through it carefully. There were photographs from the early 1900s showing the house when it was first built, receipts for materials, letters, and then I found it. The original deed, dated March 15, 1890, written in flowing script on thick paper that had yellowed with age but was still perfectly legible. The deed described the property boundaries in detail, using landmarks and measurements that were standard for that era. It referenced a large oak tree that still stood in my backyard, a creek that now ran along the edge of the neighboring property, and specific measurements from the county road. According to this document, my property was 2.3 acres, extending well beyond what the modern survey showed. My doorbell rang. Marcus stood there with a thick folder. Everything from your closing, plus I printed out the HOA's filed plat map from the county records. We spread everything out on my dining room table. The modern survey showed my property as exactly 1 acre, Lot 47 of the Meadowbrook Heights subdivision. But when I laid the 1890 deed next to it, the discrepancy was obvious. "Look at this," I said, pointing. The original property line runs along the creek, which is about 50 feet past where the modern survey puts my boundary, and it extends further north too, to that old oak tree. Marcus studied both documents. "Thomas, if this deed is legitimate, your property is more than twice the size the current records show. And look here." He pointed to the subdivision map. The HOA boundaries were drawn in 1974 when this area was developed. But if your deed is accurate, your house and at least an acre around it were never actually part of that subdivision, so they don't have any jurisdiction over me. Not even close. But you're going to need a lawyer, a good one. This is going to get complicated. I spent the rest of the day making calls. My cousin Rebecca knew a property lawyer in Boston who specialized in historical deeds and boundary disputes. His name was James Morrison, and when I explained the situation, he sounded genuinely interested. An 1890 deed. "And the property was never subdivided?" James asked. "That's actually more common than people think, especially in older areas. New England is full of these situations. Can you scan and email me everything?" I spent the next hour scanning documents and sending them over. James called back within 2 hours. "Thomas, this is solid. Your deed predates their subdivision by 84 years, unless someone in that chain of title legally subdivided or sold off portions of the property, which I don't see any evidence of. The original boundaries should still stand." "So what do we do? First, I'm going to file a response to their violations, denying their jurisdiction. Second, we need to get a surveyor out there who specializes in historical properties. I know someone perfect. Third, we're going to need to file a quiet title action to have the courts officially recognize your original property boundaries. How much is this going to cost me? I'll be honest. Probably $15,000 to $20,000 by the time we're done. But if we win, and I think we will, we can sue them for your legal fees, harassment, and probably a few other things. Do it. I'm not letting these people push me around." The next week, Patricia showed up at my door again, this time with a different lawyer and 2 board members. I recognized one of them, a balding man named Frank Garrison who lived 3 streets over. The other was a younger woman named Susan Mills. "Mr. Crawford, we received your lawyer's response," Patricia said, her voice icy. "Your claims are absurd. You cannot simply pretend you're not part of our community." "I'm not pretending anything. My property was here 80 years before your HOA existed. I have the deed to prove it." Frank stepped forward. "Look, Thomas, can I call you Thomas? We can work this out reasonably. Pay a reduced fine, say $5,000, make the corrections, and we'll forget this whole thing." "No, you're making a mistake," Susan said. "We have resources, we have lawyers. You're just one person." "I'm one person who actually owns his property." You're a neighborhood club that thinks it owns everyone. There's a difference. Their new lawyer, a thin man named Peter Young, spoke up. Mr. Crawford, even if your historical deed is authentic, which we dispute, modern property law doesn't work the way you think it does. Adverse possession, updated surveys, recorded plats, all of these things supersede old documents. Then I'll see you in court, I said. Now get off my property. Again. After they left, I called James. They came back, offered to reduce the fine to $5,000 if I comply. Don't take it. That's an admission of their jurisdiction. We've got the surveyor coming tomorrow, right? 9 in the morning. The surveyor, a woman named Dr. Alina Richards, arrived the next day with 2 assistants and equipment that looked like it belonged on a NASA mission. She was in her 60s, with gray hair and sharp eyes, and had a reputation as one of the best historical property surveyors in New England. So you've got an 1890 deed and an HOA problem, she said, shaking my hand. I love these cases. Let's see what we've got. I showed her the deed and her eyes lit up. Oh, this is beautiful. Look at this description. They use the old meets and bounds system, very precise for the time. Creek, oak tree, stone markers. Have you found the stone markers? There are old stones in my yard, but I don't know if they're markers. Let's find out. We spent the entire day walking the property. Dr. Richards used GPS equipment combined with old surveying techniques to locate the landmarks mentioned in the deed. The oak tree was obvious, massive and ancient. The creek was still there, though its course had shifted slightly over 130 years. And then we found the stones. There were 3 of them, large granite markers with chiseled marks that had been placed in 1890 to define the property corners. They were half buried and covered with moss, but they were exactly where the deed said they would be. Mr. Crawford, Dr. Richards said, standing at the northern marker, your property extends to here, which means you own not just your house and yard, but that entire section there. She pointed to an area that included part of what I thought was common HOA land, including a small playground and a section of the walking path that the neighborhood used. You're telling me the HOA built a playground on my property? That's exactly what I'm telling you. And unless they have an easement or you gave them permission, they're trespassing. I started laughing. I couldn't help it. The HOA had been trying to fine me for violations on my own property while they were actively trespassing on my land. Dr. Richards spent another 2 days completing her survey and writing her report. When she finished, she handed me a thick document with maps, photographs, and detailed analysis. This will hold up in any court. Your original deed is valid, the markers confirm the boundaries, and the chain of title shows no subdivision or sale of any portions. You own 2.3 acres, not 1 acre. And yes, that means you were never part of the Meadowbrook Heights subdivision. James filed our motion with the court, and 2 weeks later, I received a summons. The HOA was suing me for the fines plus their legal fees, claiming I was willfully defying their authority. James filed a countersuit for harassment, trespassing, and demanding they remove their playground from my property. The court date was set for 6 weeks out, which gave both sides time to prepare. But Patricia wasn't done. She started what could only be called a harassment campaign. I received violation notices almost daily for increasingly ridiculous things. My grass was too long, then it was too short. My car was parked at the wrong angle in my own driveway. I had hung laundry outside, which was apparently forbidden. The mailbox was the wrong shade of black. Each notice came with additional fines. By the time we reached the court date, they claimed I owed them $47,000, but they made a mistake. They got bold. One Saturday morning, I woke up to find a crew in my backyard, cutting down trees along the back property line. I ran outside in my pajamas. "What the hell are you doing?" The crew foreman, a young guy with a clipboard, looked confused. "HOA hired us to clear these trees. They said they're on common property and blocking sight lines." "This isn't common property. This is my land, and you need to stop right now." "Look, man, I've got a work order from the HOA. They're paying us." I pulled out my phone and called the police while simultaneously filming everything. "You're cutting down trees on private property without the owner's permission. That's destruction of property. I've called the police." The foreman's face went pale. "Hold up, guys. Stop cutting." 2 police officers arrived within 10 minutes. I showed them my deed, Dr. Richard's survey, and explained the situation. One of the officers, a sergeant named Rodriguez, looked at everything carefully. "Mr. Crawford is correct. This is his property according to these documents. Who authorized this work?" The foreman showed him the work order, signed by Patricia Whitmore as HOA president. Sergeant Rodriguez took photos of everything. "Mr. Crawford, do you want to press charges?" "Absolutely." "We'll need to contact Miss Whitmore. The tree cutting company isn't at fault here since they were hired under false pretenses. But the person who authorized work on property they don't own, that's a problem." The officers left to contact Patricia. The tree crew packed up and left, apologizing profusely. I counted 6 mature trees that had been partially or completely cut down. Each was probably worth several $1,000s. James was ecstatic when I called him. "They just handed us the case. Destruction of property, trespassing, and now we have police documentation. This is perfect." The court date finally arrived. It was a cold November morning in the district court in Worcester, Massachusetts, about 30 minutes from my home in Brookfield. James met me outside the courthouse, along with Dr. Richards, who would be testifying as our expert witness. "Remember," James said, "stay calm, be factual, answer only what's asked. The judge is Barbara Hoffman. She's fair but no nonsense. She doesn't like games." We entered the courtroom to find Patricia with her legal team, 3 lawyers in expensive suits. They had clearly decided to go all in on this. Frank and Susan were there too, along with several other HOA board members. They looked confident, almost smug. Judge Hoffman was a woman in her late 50s with steel gray hair and reading glasses perched on her nose. She looked at the docket and frowned. "This is quite the situation. HOA versus homeowner over property jurisdiction with counterclaims for harassment and trespassing. Let's start with the HOA's complaint. Miss Whitmore, you're claiming Mr. Crawford owes fines for HOA violations." Patricia stood. "Yes, Your Honor. Mr. Crawford has repeatedly violated our community standards and refuses to pay legitimate fines totaling $47,000. He lives in our subdivision and is bound by our covenants." Mr. Crawford's response. James stood. "Your Honor, Mr. Crawford is not now, nor has he ever been, part of the Meadowbrook Heights subdivision or subject to their HOA. His property predates their subdivision by 84 years, and he has never signed any agreement subjecting his property to their authority." Judge Hoffman looked interested. "I've read the briefs, but let's see the evidence. Mr. Morrison, present your case." James laid out everything methodically. He showed the original 1890 deed, explained the chain of title, presented the historical records, and then called Dr. Richards to the stand. Dr. Richards was brilliant. She explained the survey process, showed photographs of the original stone markers, displayed GPS coordinates, and presented overlays of the historical property lines versus the modern subdivision map. She made it crystal clear that my property had never been subdivided or included in the Meadowbrook Heights development. The historical property boundaries are unambiguous. Dr. Richards testified. Mr. Crawford owns 2.3 acres as described in the 1890 deed. The modern subdivision map incorrectly shows his property as Lot 47, but in reality, his parcel was never subdivided. The developers in 1974 appear to have either made an error or deliberately attempted to include his property without proper legal authority. The HOA's lawyers tried to argue adverse possession, claiming that years of treating the property as part of the subdivision meant they had acquired rights to govern it. James destroyed that argument. Your Honor, adverse possession requires actual possession and use of property, not simply drawing incorrect lines on a map. The HOA has never possessed Mr. Crawford's property. He and the previous owners have continuously owned and occupied it. Furthermore, Mr. Crawford bought the property just 6 months ago, specifically confirming it was outside HOA jurisdiction. He has actively disputed their claim from day one. Then James brought up the trees. Your Honor, not only has the HOA harassed Mr. Crawford with baseless fines, they hired a crew to cut down trees on his property, causing thousands of dollars in damage. We have police reports and photographs. Judge Hoffman looked at Patricia. Miss Whitmore, did you authorize tree removal on Mr. Crawford's property? Patricia's lawyer jumped up. Your Honor, the HOA believed in good faith that was common property. Belief isn't enough when you're cutting down someone's trees, Judge Hoffman said dryly. Did you verify ownership before authorizing the work? There was a long pause. We relied on our subdivision map, the map that's been conclusively shown to be incorrect. Judge Hoffman flipped through the documents in front of her. Here's my ruling. The evidence clearly establishes that Mr. Crawford's property is not and has never been part of the Meadowbrook Heights subdivision. The original 1890 deed is valid, the chain of title is unbroken, and the property was never legally subdivided or included in the HOA's jurisdiction. Patricia's face went white. The board members behind her looked stunned. Therefore, Judge Hoffman continued, all fines assessed against Mr. Crawford are invalid and dismissed. Furthermore, the HOA is ordered to update all maps and records to correctly show Mr. Crawford's property as separate and not subject to HOA authority. Your Honor, James said, we also request compensation for harassment, emotional distress, and the destroyed trees, plus our legal fees. Judge Hoffman nodded. The HOA is ordered to pay Mr. Crawford $25,000 for the destroyed trees and harassment, plus his reasonable legal fees. I'm also ordering a survey of all property boundaries in the Meadowbrook Heights subdivision to ensure no other properties have been incorrectly included. That survey will be at the HOA's expense. The HOA lawyers tried to object, but Judge Hoffman cut them off. This is not negotiable. The HOA overstepped its authority, harassed a homeowner, and caused property damage. You're fortunate Mr. Crawford isn't seeking criminal charges. Although, she looked at her notes, I see there was a police report filed regarding the tree incident. That's a separate matter for the district attorney to review. We left the courthouse victorious. James was grinning. That was one of the most satisfying cases I've ever argued. She didn't just rule in your favor, she demolished them. What happens now? They'll pay. They have to. And that survey she ordered might reveal other properties that were incorrectly included. This could be a much bigger problem for them. Over the next few weeks, things got interesting. The court-ordered survey revealed that 3 other properties in the area had also been incorrectly included in the HOA boundaries. 2 of them were older homes like mine, though not quite as old. The third was a small business, a bakery that had been paying HOA dues for 15 years, despite never actually being part of the subdivision. The owners of those properties all filed their own suits. The HOA's insurance company got involved and apparently told Patricia and the board that they were on their own for the legal fees because they had acted recklessly. The HOA had to levy a special assessment on all the actual members to pay the damages, which made Patricia extremely unpopular. I received my check for $25,000, plus another $18,000 for legal fees. I used part of it to plant new trees to replace the ones they had destroyed, and put the rest into renovating my 1890 house, restoring some of the original features that had been covered up over the years. But the story didn't end there. 2 months after the court ruling, I got a call from Detective Sarah Chen at the Worcester County District Attorney's Office. "Mr. Crawford, I'm investigating the incident where trees were cut down on your property. We've been looking into the Meadowbrook Heights HOA's practices, and some concerning things have come up. Would you be willing to come in and talk to us?" I met with Detective Chen the next day. She was in her 30s, sharp and professional, with a file folder thick with documents. "Mr. Crawford, your case opened a can of worms. We started looking at the HOA's financial records as part of the investigation, and we found irregularities." "What kind of irregularities?" "The kind that look like embezzlement. Patricia Whitmore has been president of that HOA for 8 years. In that time, she's collected over $2 million in dues and fees from homeowners. We can only account for about 60% of where that money went." I whistled low. $800,000 missing, give or take. "We're still piecing it together, but it looks like she's been using HOA funds for personal expenses. Vacations, car payments, home renovations on her own house. The board gave her almost unlimited authority and she abused it. We're also finding evidence that some of the fines levied against homeowners, including you, were completely fabricated to generate revenue." "So what happens now?" "We're building a criminal case. Embezzlement, fraud, possibly racketeering depending on how deep this goes. I wanted to talk to you because your case is the clearest example of fraud. You were never actually subject to HOA authority, but she fined you anyway and tried to collect. That's extortion. I'll help however I can." 3 weeks later, Patricia Whitmore was arrested at her home on charges of embezzlement, fraud, and extortion. The news made local headlines. The HOA immediately held an emergency meeting and voted to remove her as president. Frank Garrison, who had been vice president, took over temporarily. Frank actually called me to apologize. "Thomas, I'm sorry for everything. We trusted Patricia and she betrayed that trust. She showed us reports and financial statements that made everything look legitimate. We had no idea she was stealing from us, and we certainly didn't know she was going after people who weren't even in the HOA. I appreciate the apology, Frank. We're trying to clean things up. The new board is implementing oversight procedures, requiring multiple signatures on expenditures, bringing in an independent auditor. It's a mess, but we're fixing it. Good luck with that." The criminal case took months to work through the system. Patricia tried to fight it at first, but the evidence was overwhelming. Bank records, forged invoices, emails showing her authorizing fake fines to generate revenue. She had been running the HOA like her personal piggy bank. In the end, she pleaded guilty to avoid trial. The judge sentenced her to 4 years in prison and ordered her to pay full restitution of $847,000 to the HOA members she had stolen from. Her husband filed for divorce during the sentencing hearing. The tree service company that had cut down my trees ended up suing the HOA for putting them in a position where they unknowingly committed a crime, and they won a settlement. The HOA's insurance company dropped their coverage, and they had to scramble to find a new insurer willing to take them on at triple the premiums. As for me, I settled into my house and my 2.3 acres of property in peace. The new HOA board went out of their way to make clear to everyone that my property was not part of their jurisdiction, and I had no interest in joining voluntarily. I liked being able to do what I wanted with my own land. I did make some changes to the property, though. I had a proper survey done and installed a nice fence along the actual property boundaries, with a gate where the walking path crossed my land. I granted the HOA an easement to use that section of path, but made it clear it was a revocable privilege, not a right. They put up a small sign thanking me for allowing public access. I also had the old oak tree evaluated by an arborist. It was over 200 years old, a magnificent specimen that had probably been there when this area was still farmland. I had it properly pruned and cared for, ensuring it would be around for another century or more. The playground equipment that was technically on my property was a bit more complicated. The HOA wanted to move it, but the kids in the neighborhood loved that playground. After thinking about it, I told Frank they could leave it as long as they maintained it properly and carried liability insurance. I wasn't going to punish kids because the HOA board had been incompetent. Word spread about my case, and I started getting calls from other people with old properties who were having HOA disputes. I referred them all to James Morrison, who was becoming something of a specialist in these matters. He told me there were probably thousands of properties across the country that had been incorrectly included in HOAs, especially in areas where development happened around older existing homes. One evening about 8 months after everything started, I was sitting on my porch watching the sunset when a car pulled up. A woman in her 30s got out, looking nervous. She walked up to my porch hesitantly. "Mr. Crawford, I'm Bethany Oliver. I live over in Sturbridge. I heard about your case with the HOA. Come on up. Can I get you something to drink?" She sat down, declining the offer. "I have a similar situation. My house was built in 1920, and now an HOA is claiming I'm part of their development. They're threatening to foreclose on my home over unpaid fines." "Have you talked to a lawyer?" "I can't afford one. I'm a single mom working 2 jobs. I don't have $20,000 for legal fees." I thought about it for a moment. "Hold on." I called James Morrison. "James, I've got someone here with a situation like mine. HOA claiming jurisdiction over an old property. She can't afford a lawyer." "Thomas, I can't do pro bono work. I have a practice to run." "I know, but I just got 25 grand from my case. What if I fund her legal work? Same deal as mine. You win, she sues for legal fees, I get reimbursed." There was a pause. "You're serious?" "Dead serious. These HOAs are out of control. If I can help someone else fight back, I want to do it." James agreed, and Bethany started crying. "I can't let you do this. You don't even know me. My house was built in 1890. I won because someone kept those old documents safe for over a century, and because I had the resources to fight. If you've got the documents and the case, I'll help you with the resources. Pay it forward when you can." Bethany's case took 4 months, but we won. Her property predated the HOA by 60 years, and like me, she had never been legally included in their jurisdiction. She was awarded her legal fees plus damages, and I got my investment back plus a little extra. She cried again when she got the check, talking about how she had been about to lose her home. "What are you going to do now?" I asked her. "Same as you," she said. "Help the next person." We started something of an informal network. People with old properties fighting HOA overreach would contact us. We would evaluate their cases, and if they were legitimate, we would fund their legal battles. James Morrison's practice grew to the point where he hired 2 associates just to handle these cases. We won about 80% of the time, and the money we recovered always went back into helping the next person. The story made national news eventually. A feature on a property rights website, then picked up by some larger outlets. Homeowner with 1890 deed defeats HOA, helps others fight back. I did a few interviews, always emphasizing the same points. HOAs can serve a purpose, but they need oversight and accountability, and they absolutely cannot be allowed to exceed their authority. Some HOAs started being more careful after our cases got publicity. They would actually verify property boundaries before claiming jurisdiction. But others doubled down, becoming even more aggressive. Those were the ones we targeted, the ones abusing their power. Patricia Whitmore's case also had ripple effects. Other HOAs started getting audited, and it turned out embezzlement was disturbingly common. There was something about the structure of HOAs, the lack of oversight, the concentration of power in board members that created opportunities for fraud. Several states started passing laws requiring independent audits and stronger financial controls for HOAs. A year after my court victory, I was working in my woodshop out back, building a custom bookcase for a client, when Frank Garrison stopped by. He looked older, more tired than when I had first seen him. "Thomas, got a minute?" I turned off the saw. "Sure, Frank. What's up?" "I wanted to give you an update. We've completely restructured the HOA. New bylaws, elected a new board, hired a professional management company, the works. We're trying to do it right this time. Good for you. And I wanted to thank you. What you did, fighting back, it exposed problems that needed to be exposed. Patricia was stealing from us for years, and we were too trusting to see it. You forced us to look at what we had become. I just wanted to be left alone on my own property, Frank. I know. But sometimes that's enough. Anyway, I wanted you to know that we appreciate the easement for the walking path, and if you ever need anything, just ask." He left, and I went back to my bookcase. Life settled into a comfortable rhythm. My carpentry business did well. I dated a bit, nothing serious. I spent my evenings on the porch, reading books and watching the seasons change over my 2.3 acres of property. The oak tree became something of a landmark. I put a bench under it and opened it to the public. People would come to sit in the shade, kids would climb on the lower branches, and occasionally someone would thank me for keeping it accessible. It felt right, sharing something that had been there for 2 centuries and would hopefully be there for 2 more. I also restored more of the house, bringing it back to its 1890 glory while adding modern conveniences. The work was satisfying, uncovering original hardwood floors, restoring the stone fireplace, rebuilding the front porch to match old photographs. Every nail I drove felt like honoring the people who had built this place over a century ago. One afternoon, I was replacing some rotted wood on the porch when I found something interesting. Behind a piece of trim, someone had carved initials and a date. J.M., 1890. Jacob Miller, according to the deed, the original owner and builder. I carefully preserved that carving, incorporating it into the new trim work. It felt important to maintain that connection to the past. The HOA cases continued. We helped a retired couple in Vermont, whose 1920s farmhouse was being threatened by a new development's HOA. We assisted a veteran in New Hampshire, whose family property from the 1880s was facing similar issues. Each case was different, but the pattern was the same. Old properties, new HOAs trying to assert control they didn't have, and people who needed help fighting back. James Morrison gave a presentation at a property law conference about these cases. The legal community was starting to recognize this as a real issue. Some law schools even began teaching courses on historical property rights and HOA overreach. Our case, the one that started it all, became a standard example in these classes. 2 years after my original court date, I received a letter from the Massachusetts Attorney General's office. They were investigating HOA practices statewide and wanted to interview me about my experiences. I spent 3 hours with their investigators, walking them through everything that had happened. "Mr. Crawford," the lead investigator said, "your case exposed systemic problems in how HOAs operate. We're seeing evidence of fraud, extortion, and abuse of power across the state. Your willingness to fight back and help others has been instrumental in bringing these issues to light. I just wanted to protect my property." Sometimes that's how change starts, one person refusing to be pushed around. The Attorney General's investigation led to criminal charges against 4 more HOA presidents across Massachusetts, and civil actions against dozens of HOAs for various violations. The state legislature passed new laws requiring HOAs to register with the state, submit to annual audits, and provide homeowners with clear dispute resolution processes. My house became something of a destination for property rights advocates. People would stop by to see the place, to talk about their own struggles with HOAs. I didn't mind, as long as they called first. I turned part of my barn into a meeting space where we could gather, share information, and plan legal strategies. Bethany Oliver became a regular visitor. She had gone back to school for a paralegal certificate and now worked part-time for James Morrison, specializing in these cases. "You changed my life," she told me once. "I was about to lose everything and you stepped in. Now I get to help other people keep their homes." You would have done the same for someone else. Maybe. But you did it first. 3 years after the original incident, Patricia Whitmore was released from prison after serving her sentence with good behavior. I heard through Frank that she had moved out of state, trying to start over. Part of me felt bad for her, how one series of bad decisions had destroyed her life. But mostly, I remembered how she had tried to bully me out of $47,000 for violations on property she had no authority over. The playground on my property got an upgrade. The HOA asked if they could replace the old equipment with new, safer structures, and I agreed as long as it was done properly. They hired professionals, got all the right permits, and built a beautiful play area. They even put up a small plaque thanking me for allowing it on my property. Kids played there every day, and that made me happy. I expanded my carpentry business, hiring 2 employees and taking on bigger projects. We specialized in historic restoration, which was fitting given my house. People who owned old homes wanted someone who understood and respected their property's history, and I had built a reputation for quality work. The old stone markers that defined my property boundaries became something I maintained carefully. I cleared the brush around them, made them visible, and added small informational plaques explaining their history and significance. They were 135 years old, physical links to the past, and I wanted to preserve them. My cousin Rebecca, who had recommended James Morrison, came to visit one summer. We sat on the porch drinking beer and watching fireflies in the yard. "You know, Thomas, when you called me about your HOA problem, I never imagined it would turn into all this. Neither did I. I just didn't want to pay bogus fines. You started a movement. People fighting back against HOA overreach, protecting property rights, holding these organizations accountable. That's significant. It shouldn't have to be significant. People should just be able to own their property without harassment. True. But that's not the world we live in. So someone has to stand up. I'm glad it was you." We helped our 50th case in the 4th year. A couple in Rhode Island with an 1870s house, facing an HOA that wanted to force them to demolish and rebuild to match neighborhood standards. We won, and the HOA was ordered to pay damages and legal fees. The couple sent me a thank you card with a photo of their beautiful Victorian home, saved from destruction. I framed that card and hung it in my workshop. It reminded me why this work mattered. It wasn't about money or winning legal battles. It was about protecting people's homes, their history, their right to be left alone on their own property. The 5th anniversary of my court victory, James Morrison threw a party. It was held at a nice restaurant in Worcester, and he invited everyone who had been part of these cases over the years. Homeowners we had helped, legal associates, Dr. Richards the surveyor, even Frank Garrison showed up. 5 years ago, James said in his toast, Thomas Crawford refused to be bullied. He fought back, and in doing so, he changed how we think about property rights and HOA authority. To Thomas, and to everyone here who has stood up for what's right. Everyone raised their glasses, and I felt genuinely moved. I hadn't set out to change anything. I had just wanted to drink coffee on my porch in peace. But sometimes that's enough, refusing to accept injustice, standing your ground, helping others do the same. Life continued in my 1890 house on my 2.3 acres. I never did join an HOA, never felt the need to. My property was mine, and I took care of it the way I saw fit. The wildflowers still grew in the back corner. My fence was exactly the height I wanted it. My shutters were dark green, and nobody could tell me otherwise. The oak tree continued to grow, adding rings year by year, a living testament to the passage of time. I had it evaluated again by an arborist who estimated it could live another 100 years with proper care. I put money aside in my will to ensure someone would maintain it after I was gone, keeping it accessible to the public, preserving that connection between past and future. Sometimes on quiet evenings, I would sit on the porch and think about Jacob Miller, the man who built this house in 1890. What would he think of all this? His house, still standing 135 years later. His stone markers still defining the property boundaries. His oak tree still providing shade and beauty. His deed holding up in a modern court of law. I like to think he would be proud. He had built something to last, and it had. Not just the physical structure, but the legal foundation, the clear documentation of ownership, the careful placement of markers. He had done it right, and that had made all the difference. My house stood as a reminder that some things endure. Property rights, clear documentation, standing up for what's yours. These weren't abstract concepts, they were real and important. Patricia Whitmore and her HOA had tried to take that away, and they had failed. The law, ancient deed in hand, had sided with history and justice. As the sun set over my property, painting the sky in shades of orange and purple, I raised my coffee cup in a silent toast to Jacob Miller, to James Morrison, to Dr. Richards, to Bethany Oliver, and to everyone who had fought to protect what was theirs. We had won, not just in court but in preserving something important, the right to own property free from unjust interference. My 1890 deed, yellowed with age but still legally valid, sat in my fireproof safe. It was more than just a document. It was proof that some things matter beyond the immediate moment, that careful work done right can protect people generations later, and that standing up for your rights, even when it's hard, even when it costs money and time and stress, is always worth it. The Meadowbrook Heights HOA learned that lesson the hard way. They paid for my legal fees, my damaged trees, my harassment, and their own court-ordered survey. They paid in reputation and community trust, and Patricia Whitmore paid with her freedom. all because they tried to claim authority over property that was never theirs to govern. I never regretted fighting back, not for a single moment. And as I sat on my porch on my 2.3 acres, watching the stars come out over my 135-year-old house, I knew I had done the right thing. Sometimes standing your ground is the most important thing you can do, not just for yourself, but for everyone who comes after. The story could have ended differently. I could have paid the initial fine, accepted their authority, let them push me around. Many people would have, just to avoid the conflict. But I had my deed, my history, my rights, and I wasn't willing to surrender any of it. That choice, that refusal to back down, made all the difference. Not just for me, but for 50 other families we helped, for the laws that changed, for the HOAs that reformed, for the awareness we raised about these issues. One person standing up can start something bigger than themselves. I learned that over 5 years of fighting, winning, and helping others do the same. My 1890 deed predated the HOA by 80 years, and that simple fact, that historical truth, was enough to tear down their entire case and expose the corruption beneath. Justice, it turns out, sometimes moves slowly. But when it arrives, backed by solid evidence and unwavering determination, it's unstoppable. The HOA sent lawyers over my property line, confident in their power and authority. They found instead a homeowner who wouldn't budge, a deed that couldn't be disputed, and a legal system that ultimately sided with what was right. And that's exactly how it should be.